Hi, this is Brian Dolan with the law firm Pepper Hamilton. On a monthly basis, Pepper partner Greg Nowak hosts an investment management webinar for West LegalEdCenter. This month, they focused on the topic Enterprise Risk Assessment. Greg invited Adam Depanfilis, Director at KPMG, and Jeff Lindenbaum, Chief Executive Officer at CQS, to join him. They discussed the following topics: defining and understanding enterprise-wide risks, addressing regulatory requirements for dealing with enterprise-wide risks, and also effective compliance strategies in today's regulatory environment. You can download a copy of the PowerPoint slides they discussed by visiting Pepper's Insight Center at www.pepperlaw.com, where this podcast is posted. Thank you.
This is Greg Nowak from Pepper Hamilton. I'm a partner in the Financial Services Group in New York and Philadelphia, Pennsylvania, and welcome to our first program of the fall for investment management and what's happening now. I'm joined today by a number of luminaries in the industry, two partners from KPMG LLP, Adam Depanfilis and Sean Gleason. And then we also have a treat. We have Jeff Lindenbaum, who's the Chief Executive Officer of a hedge fund, CQS, and he's going to tell us why all of the things that the three of us in the ivory tower are saying is completely wrong when it comes to risk and risk assessment. So without further ado, we're going to get right into the materials. And if you'll notice, I've listed a few topics on slide 3, which are the recent developments that we've seen that have come out of the SEC. And in particular, I'd like to use these as a jumping off point to tee up why not just compliance, but more importantly, the larger question of risk assessment and enterprise risk is just so important right now. If you take any business and you do a quote-unquote risk-adjusted return analysis, and you then say, well, they're returning as an equity investment 10%, but now after you take into account the fact that they may have a multi-million-dollar settlement with FINRA or the SEC or the CFTC, the true value of that firm is now risk-adjusted, much less. That puts into fairly sharp focus the issue that we're focused on today, and that is enterprise risk. So let's talk about some recent enforcement developments and other developments in the space that I think will nicely dovetail with the enterprise risk assessment program that our two speakers are going to address. So first, and probably one of the biggest issues that came out this past summer, was the Blackstreet enforcement action. Now, Blackstreet had bad facts. We had a firm that was a registered investment advisor, not a registered broker-dealer, a private equity firm that was involved in selling interest in their portfolio companies. Now, they fully disclosed everything about what was happening with this sale and told their investors that they would be taking these fees. Notwithstanding the fact, the SEC sued and alleged Section 15A violations. For those of you who don't know 15A off the top of your head, that's the section of the Securities Exchange Act of 1934 that says it is illegal to engage in the sale of securities on an agency or principal basis unless you're registered as a broker-dealer or unless some exception applies. So in the Blackstreet case, even though there was full disclosure, the SEC still required $1.8 million in disgorgement because the firm was engaged in activities which needed a broker-dealer license. Now, one of the things we see all the time are people who say, well, I've got a broker-dealer license, and it's hung with XYZ brokerage firm. That makes it all okay, right? And the answer, of course, is no. And FINRA will tell you this in a nanosecond, if you want to rely on the protections of the broker-dealer, and in fact, if you do have a license and it's active, you must involve the broker-dealer in anything dealing with the sale of securities, then the trade must go through the broker-dealer. The broker-dealer must take its fee. And then if it shares that fee with a licensed person, then everybody's happy. But if you are attempting to say, well, a broker-dealer is an affiliate or somehow on the scene, that's not enough to protect you against a Blackstreet-type enforcement action. So the risk there is that people are playing fast and loose with the facts, number one, or number two, thinking that disclosure solves all things. It solves a lot, but it doesn't solve a fundamental violation of the federal securities laws, and in the case of Blackstreet, it was acting as a broker without a license. So then everybody pointed to the final adoption this past August of the capital allocation broker rules. Oh, that means everything's okay. And the answer is no. The capital allocation broker rules would not have held the Blackstreet. We're not going to go into those. In fact, they'll be a topic of one of our seminars going forward. But suffice it to say, this issue has been kicking around for 20 years. The SEC and FINRA finally approved a series of black lines that allow for capital allocation brokers to take fees and not be licensed under certain circumstances. But it is not open season, and it certainly does not solve the Blackstreet fact pattern. So then there were some other recent developments over the last couple of months. Probably one of the most celebrated was the SEC suing Leon Cooperman and Omega Advisors, alleging insider trading. The facts that are set forth in the complaint, which came down a few weeks ago, say that hedge fund legend Cooperman got to an executive at one of his portfolio companies and got information from that executive about when a particular transaction was going to occur, on the condition that the information would be kept confidential. The SEC further alleged that the investment advisor here took that information and traded on it ahead of the sale, and as a result benefited substantially when the transaction that the executive had mentioned occurred. That's classic material non-public information. And then finally, 17 months later, when a subpoena is issued, the investment advisor allegedly called that same executive and tried to conjure a story that would explain away how he was able to trade on material non-public information without it being an issue. So again, another issue of risk here is, how are you gathering information? And are you certain that you're gathering that information in a way that doesn't violate anybody's fiduciary duty? The classic element of a Dirks case for TIPI liability is that an insider with a fiduciary duty sells information for some benefit, whatever that benefit might be. Does it have to be monetary or personal, or can it simply be a psychic benefit? Those are all issues being litigated at the moment. And that the person who receives the information knows that the insider has breached his fiduciary duty and therefore uses that information in a way that personally benefits him. Even a remote TIPI can be brought under the Dirks jurisprudence if you have all of those elements of knowledge, breach of duty, and then a pecuniary benefit. Cooperman is actually a slightly different case. There, he breached a duty because he was brought, quote-unquote, under the tent by having the information given to him under a seal of confidentiality. Now, of course, this is all an allegation of the SEC. We don't know whether or not that has actually happened. But the risk here is that as a portfolio manager or a firm, do you know how your people are getting their information? Are they participating in expert networks or information exchanges or blogs or some other source where there could be viewed as a violation of one of the tipper rules? Another area of risk that we've seen is whistleblower suits. Now, when the SEC and Congress came out with their whistleblower rules, they said, or a lot of the bar responded by saying, well, we'll have people contractually agree that they won't whistleblow, or that if they do, they can't take the benefit derived from that because we think that they should be talking to us first. We're the employer. We're the ones where they work. We pay their paychecks, so therefore they should have a degree of loyalty to us. The SEC, in the matter of HealthNet, Inc., said categorically, if you have contracts that prohibit your employees from bringing whistleblower suits or benefiting from the proceeds of a whistleblower award, those contracts are void. Not voidable, but void. And if you have them, you've engaged in an activity which is contrary to the federal securities laws, is a fraudulent practice. And so you now need to go back and take a look at all of those employment agreements and make sure there's no gag order in there, or gag provision is, I guess, a better way to describe it, And again, an element of risk that we thought we were controlling by embedding these types of provisions in offer letters and contracts, employee handbooks. Now what the SEC says in this enforcement action, no, you can't do that. Overstatement of assets under management, the Fortius and Bollinger case. Again, another enforcement action. Fairly straightforward. Most of us would know fairly quickly that, or intuitively, that if we say we have $10 billion of assets under management and we really only have 2 or 1 or 10 million, that's somehow, some way going to induce someone to do something with us that they probably wouldn't have done otherwise. The problem is you're doing it on a form that you file with the government, and that not only is a misrepresentation or fraud in the inducement, but it's also a fraud in a report. And the FCC has said that overstated assets under management need to be remedied rather quickly. So then, of course, my favorite of the cases that came out this summer, the Rathco Management Group case, in which the plaintiffs attempted to get the SEC to stop suing them on a particular matter on the grounds of selective prosecution. And it's the classic, well, wait a minute, Billy down the street does it, and he never gets in trouble. How come I'm getting in trouble for doing the exact same thing? Well, according to the court, in order to sustain a case or an argument that you have been unfairly singled out for prosecution, it has to be based on an improper consideration of factors such as race, religion, or the desire to exercise a constitutionally protected right. So unless you have been selectively prosecuted because of your race or because of your religion or because you're exercising a constitutional right, like I guess the Second Amendment might be an example where someone would say that we're going to prosecute all gun manufacturers because we don't like guns, or we're going to, investigate Tea Party political action committees because we don't like their politics. That would be one of those examples of selective prosecution, at least in the eyes of the SEC and the courts. All others are fair game, and it makes sense. They can't be everywhere. They can't sue everybody for every infraction, and so much like the IRS, they go after the headline cases in order to make sure that people understand what the rules are, where the line is, and how tough they can be when they really want to be tough. And that, again, is part of the risk assessment analysis, so-called headline risk, and have you raised your profile on an issue where perhaps cooler heads would say maybe we should pull back. Another matter which I found fascinating was the Chin enforcement action that came out this summer. And let me just read a transcript that was included in the complaint filed against Edwin Chin. On the morning of July 25th, 2011, Chin negotiated the purchase of a $10 million piece of an RMBS, agreeing to buy it from a hedge fund customer at a price of 45-24. In other words, 45% of par plus 24 ticks. At approximately 11:22, Chin received written confirmation of the trade at that price, so 45-24. Approximately 5 minutes later, at 11:27, Chin sent an instant message to a representative of a different hedge fund customer of Goldman, inquiring whether customer A remained interested in buying the same instrument. Chin implied that he was actively negotiating with a third-party seller, asking, quote, do you still care on the sale in the H47s? I think there might be something to do there, otherwise he's going to show it anyway. H47 is a shorthand reference to a price that's between 47 and 48% of the bond's fair value. After the customer A representative indicated an interest in buying the bond at a price in that range, Chin wrote him another instant message at approximately 1:08 p.m. in which Chin misled the customer. Quote, I can get you $10 million of that instrument at 47.24. This guy was really painful, and I couldn't get him to sell any lower. You can pay me something next time. After receiving this information, customer A agreed to purchase the bond at 47.24, and this is the SEC's argument. Chin misled customer A into believing that Chin was conducting active negotiations with another hedge fund. In actuality, Goldman had purchased the instrument earlier that morning at $45.24, not $47.24, and held it in its inventory at the time of the sale to customer A. Chin therefore misled customer A about the details of a negotiation. Specifically, Chin misrepresented whether Goldman already owned the RMBS being sold and the suggestion that because of a tough negotiation, Goldman was selling the bond to customer A at cost and receiving no compensation on the trade, when in fact Goldman earned 2% or 64 ticks on the trade. Chin's misleading statement affected the purchase price by the customer. The customer A would have attempted to obtain a lower price had it known the truth. And so now trading sales activity, a huge risk for every organization with a trading desk, is now in full glare of the SEC, where what would previously have been viewed as puffery is now being viewed as intentionally fraudulent conduct. This is one where I think if this holds up and if Mr. Chin does an appeal, I could see that being a major, major risk issue on every trading desk at every asset management firm. How do you police what your traders are saying? And then, of course, the last one that, came out this summer was the Apollo case, where an executive was charged with charging expenses for his paramour to the fund, for allocating monitoring fees inappropriately, and for other violations. And given the profile of the participants, this was a huge enforcement action this summer, and hedge fund manager agreed, or the private equity manager agreed to the fix. So, gentlemen, I put it to you. We have all of these cases, all of them representing in one way or another bad facts, but as we know, bad facts happen every day. So how do we approach this from a risk enterprise point of view? Start with you.
Sure. Hi, everyone. It's Adam Depanfilis from KPMG. I would say that the first thing that struck me in all these cases, and we've seen a lot of this over the last, I'd say probably starting with Madoff, is the SEC no longer is worried about just what you disclose, as you mentioned, Greg. Now they actually care more about what's right for the LP or what's right for the customer. When in the past, at a number of shops that I've seen, it's really come down to, hey, as long as you tell them you're doing it, it's okay. This goes back to everything they do with expense allocations and a number of the other activities that we've seen over the last couple of years be tops on the SEC's list. But again, it goes back to now actually having to think about what is right for your LPs. And to that same point, and Sean will get into this in a minute, but identifying these risks that you have. A lot of these funds have been doing the same thing for a number of years, and it gets down to the point where, hey, I've been doing it for the last 15 years, and it's nothing has changed on my side. Why should I need to change my business plan to be different now?
So let me interrupt for a second and ask Jeff.
Yep.
Jeff, CEO of a fund management firm, you just heard this parade of horribles,
yep.
And obviously we know nothing like that would ever happen at CQS. But you're sitting astride a large firm and you're saying, like at the top of the pyramid, all this information flows up. How do you manage that process?
We have invested a tremendous amount in clients, primarily in people, but also in systems. So, you need to be monitoring what's going on in your trading every day on a live basis. And we have our compliance team getting reports every day and following up with traders. And the most important thing is that follow-up with traders. So, I know that the SEC talks a lot about a culture of compliance, and we really do believe it is important. And if you just have your compliance team in the back room and just doing stuff and sending an email or making a phone call from time to time to a trader, you'll get answers. But if you have them engaging face-to-face, right, and sharing the information, letting them see that we're really on top of this stuff, and, bad excuses don't work, I think that does infuse in the traders that culture of compliance, because they have to live it every day and they know it. And they should respect it, right? And so for us, what we have found is because of the way we engage with our, with all the traders and research people in the firm is more times than not, they're coming to us before we ask the question. And that for us is a major ability to assess whether compliance is being taken seriously as a firm. And then we have certain metrics that we now have our compliance team put together in terms of violations and so on. So we can see, are things getting better, are things getting worse, are there serial violators and so on, and what are we doing about them, taking actions accordingly.
So basically you're saying you expect everybody to own it up and down the chain and percolate issues up as quickly as possible and then have a plan of action to address those issues that are identified.
Right. And most importantly is if you think it's questionable or you have a question about something, this is a place where you don't act and ask for permission later. You ask permission up front, and that's important.
So let's talk to our consultants here. How do you take, a good compliance culture like that and then look around the corners? Look for the stuff that's coming out of nowhere that's going to blindside you. Like, for example, this little colloquy that I just read from Mr. Chin, which, of course, you get that because they're on a recorded line, and all that's preserved. And when the SEC gets a complaint from somebody, and this came out because somebody complained that they thought they were losing their shirt on the trades, they go back and listen to the tapes, and then they take from the tapes the data. So how do you look around those corners to see the next thing that's coming?
Well, Greg, it's interesting that you asked that. So first of all, I'd like to introduce myself. I'm Sean Gleason. I'm with KPMG, and on behalf of KPMG, I want to thank Pepper Hamilton for inviting us to this.
Our pleasure.
Very important topic to not only us but to the industry. I know you spent a lot of time talking about the SEC and how it's a hot-button item for them, but it's also a hot-button item for the investors, right? So our investors are becoming more sophisticated. They're coming in and asking questions a little bit more about risk. So how do you look around the corner, I think, is really about a bottom-up approach from performing a risk assessment, understanding what your risk landscape looks like through actual, testing, getting people out in the field, down at the lower levels of the organization, and boiling it up, right? And that seems like an easy thing to do when you've got a culture of compliance and you think everybody's kind of bringing up all of the issues that may be hot at that moment. But the question really is, how do you look beyond today or tomorrow and things of that nature and look into the future? And to me, it's with a risk assessment. And it's creating that common language of risk across the firm. I tell a funny story about, a client of ours that we went and, talked to them about risk assessments. What are you guys doing to understand the risk, either from a technology perspective, strategic, operational, financial risk? And you start asking them, and they said, well, we did a risk assessment, we came up with 140 different risks. How do we even manage that? And the answer is you can't, right? I don't know how you manage 100.
We are in the risk business, right? I mean, if you think about it, if you don't have risk, you don't have reward. So
very true. But what we try to do is consolidate those risks to a common language, right? We like to bucket them into 4 different areas: strategic, operational, compliance, and financial risk. And when you bucket them into those areas, you can all start focusing on which areas are most important to you. So if you, Jeffrey, have a very good compliance program, then you may not need to spend as much time focusing on compliance. You might need to look at your financial reporting or your operational risk, which includes business continuity, disaster recovery, some of the key man risks that we're seeing now from key man departures and things of that nature. How can our firm react? Cybersecurity, huge thing, right? A lot of firms and funds that are our size and nature are starting to focus on that more.
Yeah, and for those following at home, we're focusing on slide number 13 in the package, the 4 buckets of risks: strategic risk, operational risk, compliance risk, and financial risk. Sorry to interrupt, but go ahead.
No worries. And so what we try to do is we bucket those, and there's a couple that are in that yellow central box there that we feel are pervasive across those 4 buckets, right? So those are our central risks. And to the folks on this call and in this room, I think we would all agree that reputational risk is one of the biggest risks we have. There's a lot of funds out there. There's a lot of product offerings and, a lot of similar looks and feels at these funds. And if somebody has a black eye from the SEC, or if they've had that cyber breach, or they've had that, information walls kind of disaster, where information has leaked, then that's going to be a differentiator for some of the larger investors.
So just looking at your yellow box here, Apollo, obviously reputation risk. Cooperman, obviously reputation risk. Huge in both of those cases. HealthNet, the whistleblower, I don't know which one you'd put that into, maybe information security, because you're trying to protect your information. The SEC is saying, well, there's a higher duty here, and that higher duty is to us in the system, and you can't stop people from passing that information on higher up the chain. The AUM, that obviously is fraud. Someone is fraudulently attempting to induce people to do something. Selective prosecution, well, that's just outside of that I think is your black swan, right? You can't figure out how to deal with that. But, the trading risk that we talked about, that sort of touches on all of them, right? It's fraud, it's reputation. I mean, Goldman Sachs is prominently mentioned here, even though they were essentially an innocent party. It just happened on their watch. Information security and information technology. How come this, the evidence was presented because E in email stands for evidence, as we all know, and the recorded line transactions are all there. So, obviously these are the risks. How do we come up with that common language? I know if we go back to your slides, beginning on slide number 6. You walk us through that common language of establishing a way of talking about risk.
And just before we get into that, you brought up, you said a number of times, risk-adjusted returns. We're all in the business of making money. When you think about your investments, right, you're thinking about weighing the potential reward with the possible risk. I've known a lot of very smart fund managers that have said, one bad investment or a couple bad investments will never bring down my fund. But one piece of bad an issue from a reputational standpoint will bring down the fund. So unless you're a startup fund that needs to, have a good track record in the first year, any established funds, these risks, while they may not seem like they should be on the minds of your investment side guys, they should be, because these are the things that, one and done. There's no 3 strikes and you're out on some of these cases that you spoke about.
Yeah. And we'd like to talk about, the founder of our firm, Michael Hinsey, he always likes to say, I'm paid to take investment risk, not operational risk.
Yeah.
And so we make sure that all aspects of those operational areas that you talked about on that page are well covered. And the other thing is, I think it's a matter of staying diligent on all of them, and so that if you find that, we've got this one covered, so we're going to shift gears and focus on that one, one has to be careful about how much shifting one would do, because if you start to disinvest, if you will, in some of those operational areas, what can creep into the system. So I think a matter of being diligent on an ongoing basis and making sure that, look, if you want to find efficiencies and use of human capital, if you have technological solutions that hopefully maintain what you've done and hopefully enhance what you've done, frankly, so that, and then how does it all fit together? How is it reported up to management? And how does management react to a lot of that stuff? And so for us, we want to make sure that, we're not only on top of any operational errors or any compliance breaches or whatever, but where do we stand even on the trading side, and where are we on, breaks and things like that, and what's the trend in settlements, and are things taking longer? Because that brings about potential operational risks, which equate ultimately to investor risk, and then later on, hopefully not getting too far down the road, but if it does, then you've got a reputational problem.
Yeah. So information issues, and issues about or information about a violation can come from a couple of different places, right? It can come from an investor who sees a pattern or just is aggrieved, doesn't like the fact that they lost money. Of course, investors never, make bad investments. It's always somebody else's fault. Yeah. So you have that issue, an investor who's aggrieved for some reason, and feels he hasn't gotten a square deal, or that he shouldn't have had that loss, or somebody exceeded authority, whatever the case may be. But ordinarily, that's where the investor doesn't like the outcome, goes to his lawyer and says, "Give me my money back." And then the lawyer is looking for a deep pocket, looking for somebody to make them whole. And, the most effective tool, I will tell you, as the lawyer in the room, is to force someone to recognize that there was a breach of a duty of some sort. Because as soon as you can get the person on the other side of the table to acknowledge in his own mind that there is an exposure, whether it's a reputation risk or otherwise, because they did something not necessarily wrong, but maybe not right. Now, there's a difference between those. Then all of a sudden you have settlement leverage, and you're going to get whatever you need for your client in that circumstance. So you have the investors who are always looking for the best deal for themselves. Then you have the regulator who's supposed to be standing in for the investor and catching these things before the investor is harmed. So that's almost like a preventive. But then you have your super investors, your institutions who come in and say, "Let me see your risk assessment. I want to know how you've addressed these issues in the operation of your firm." And then I guess you have the internal, right? The people internally who are saying this isn't right or this isn't the way this should be done, the whistleblowers. So those are your sources of information. Then how do you deal with that?
We're actually getting down the road now where institutional investors are demanding these things before they come into the fund.
Right.
Sitting through, both Sean and I were on the private side 2 years ago. Both Sean at a big private equity firm, me at a mid-sized hedge fund, and we both sat in on the operational due diligence meetings for the last, 7 to 10 years, and just seeing the demands of the LPs now, especially the larger institutions. Okay, let's talk about your risk assessment. Sometimes they don't say, "Let me see it." They say, "Prove to me you have it, and show me the framework that you're going about to identify these risks." We understand that once you find them, you're going to strategically, address them, but prove to me that you're actually trying to identify them.
And that's correct. And I think, Jeffrey, you brought up a good point, which is not forgetting a risk once you've addressed it, right? And creating that methodology around it, I think, is so important to create a repeatable process that you can engage on a yearly basis where you're making sure that you aren't forgetting those risks. They may have a lower score, but they're going to be on your roadmap. So I think that's a good point. And the other thing that I would just like to talk about for a minute, because you brought that up, is the hesitation that a lot of firms have in doing a risk assessment. The question I get asked all the time is, well, isn't this going to create a roadmap for the SEC to find all my dirty laundry? And that's a very good question to ask, because a lot of the smaller size funds are like, listen, I've been flying under the radar. I'm doing well. We're staying we're keeping our nose clean. I don't know if I want to do this, because now I'm going to be creating a roadmap for the SEC to create issues for me and, havoc. That's a misconception, and I'm just going to squash that right now, because I faced off with the SEC on a number of items on the private side, as Adam mentioned. And when they saw that we did something, they gave us credit. So they said, all right, well, you are coming in and doing risk assessments across the firm. You've identified a 3 to 5 year plan for remediation and mitigation of that risk. Good for you, right? They're not going in and saying, all right, well, you've identified this sort of risk. Now I want to keep digging into that risk. They actually pulled off rather than digging deeper, because they saw that we had a methodology in place. We had a repeatable process in place. We had a plan to remediate and mitigate the risk. But I know that that's probably in a lot of the folks' minds here, because it's a question that we're asked all the time. So I just wanted to.
Well, I think that's a really good point. Let me give you a more effective roadmap, and that is your attorney's bills. Okay? Now, normally any communication between a client and an attorney is privileged. But how often have the clients turned their legal bills over to their accountants to do a review, thinking that the lawyers have somehow, some way cheated them? Next thing you know, because that legal bill has been disclosed to the client, or to the accountants rather, it's no longer a privileged document. And so clients will say, oh, I want more detail, and then you'll see some attorneys put a paragraph of information in that describes exactly what they did and everything, thinking it's going to be privileged, and not recognizing that the client, whether inadvertently, intentionally, whatever, has just breached the privilege. And now the SEC comes in and they say, so we see in this email that you sent all the legal bills to the accountants for review. We'd like to see them too. And you say, but they're privileged. And you're like, well, no, they're not. You've just disclosed them to a non-privileged party, so therefore we get to see the bills. And if you want a roadmap, that is the clearest roadmap to what's happening in that firm and the issues being addressed. And so I always tell, my clients they'll get a verb and a noun in the detail. That's about it. Reviewed document on X, because anything more than that, you have no idea if the privilege has been breached and whether or not you've just created that roadmap. So that's another element of risk assessment that firms need to keep in mind, asset management firms, because you have no idea where the subpoena is coming from and how they're going to get that information, because the information is all there. Every one of these cases is built on emails, voice transcripts, or other information that's been obtained from the company through their due diligence and investigatory process.
And think about a lot of the firms that you deal with, and Sean will talk about the 3 levels of defense in a minute, but you deal with firms of all sizes, right? So who knows which person at what rung on the ladder is sending that legal bill, which he thinks is fine, to the accountant, right? It's not necessarily, Sean will talk about the tone from the top, and maybe your CEO will say, whoa, why would you ever do that? The risk of sending that and making that document no longer privileged that's much higher risk than what we're getting for saying that, we got cheated out of some money. So having that, the person at the top that can or the chief compliance officer that could sit at the top and see all the different risks associated with it, getting that thought process down to even the business owners that think, they're just thinking, we got taken for a little bit with these legal bills, so hold on, let me do it here.
Well, first of all, if your CFO thinks they're getting taken with their legal bills, it's got a bigger problem, right?
Yeah.
You have a problem of trust there that has to be repaired before you start, hitting somebody over the head with an accounting review. But let's talk through on slide 6 your 6 principles of a good risk assessment program. So, we talked about we need a common language, and I think we all think we know what risk is, but it's different in every firm, and there are the different types of risk, like we talked about with the blue slide with the yellow box in the middle, and most importantly, what are you as the officer in charge of the firm concerned about? How are you going to address those things? But tell us about the holistic view of risk aligned to strategic business values. What exactly do you mean by that?
So this really gets down to what I began to mention before about understanding the risk across the firm, right? So compliance will be, a good place to house these risk assessments because most of us don't have internal audit unless we're public or we're using some sort of using a third party to do individual audits or things of that nature. But compliance is what I see, or in the CFO office, where they kind of have that spider web, if you will, across the entire firm. So what happens is when you start looking at the risk in each individual, let's call it front office, middle office, back office, and operations, it starts to boil up, right? And you start identifying these individual risks that we mentioned with the blue boxes and the yellow boxes. And how those risks, once you've identified 5 or 6 risks that are firm-wide, you really want to start looking at how it aligns to what your business values are. So are we a firm that's going to pride ourselves on a risk-based and make it known on a risk-based mindset, or are we, and by making it known, it's something that we included in our investor deck quite a bit. So we would create an entire page on our investor deck on how we're managing our internal risk. So we had risk and internal control. We had a page around risk and internal control, and people found that to be quite valuable. And that kind of solidified and backed up what our values were as a firm. So I think what's really important about the second principle here is really about, understanding the pervasiveness of the risk across the firm using that common language.
So you've identified a common language, you've looked at your whole firm, and now have a holistic view of where, the black swans are coming from. Mm-hmm. And now you identify specific roles and responsibilities within the organization in both identifying the risk and also dealing with the risk. Correct. So how do you go about that in a small shop? You have 10 people.
Right. Small shop of 10 people, you pretty much just ask somebody to, you identify one of the emerging risks and topics, right? So let's say it's, trading desk activities, which is something that you had mentioned in one of your earlier items. What you do is sit there and try to flow out what that process is from end to end. And you ask somebody specifically to say, if I'm going to understand this process from end to end, who's involved, from trade inception to how it hits the GL, I want to understand everything in between it. That's the first step, right? So you identify that role as being somebody that's going to document the process, right, and understand that process intimately. When you've done that, then you start identifying through some tools that we've included in here what the different risk triggers could be. So if there's technology involved, you've got a lot of different things that are going to be there. So you've got, access is going to be an issue. Who's got access to the trading platforms? Is it appropriate? Is that access needed? Do we have third parties accessing any of our systems throughout this process? And you start asking yourself these real questions about, okay, how much exposure do I have to either information technology risk, operational risk, compliance risk, so on and so forth? Do we have the right sign-offs in place? Oversight and governance becomes a really important piece to this because then you're policing yourself. You have
Even in a small shop.
Even in a small shop because, in a small shop, people are wearing many hats, right? So you've got somebody that's doing operations and accounting and all of that stuff, and they're probably, maybe ordering supplies as well, or they're just wearing multiple hats. So having some sort of check and balance in that process is very, very important.
An example of that we saw at a small shop that the access to book trades, an admin assistant had it, and it was strictly because the traders like to say, "Here, put this in the system." We went in and said, "I know that you're trying to be efficient, but she should not have access to be able to book trades on your behalf. Only authorized traders should be there, no matter how small the shop you are, and we know you're trying to create efficiencies, but at some point you have to say, not everyone can do everything. There needs to be specific roles and responsibilities." Just an example of how one small change at a small shop takes away some of that risk.
And wires, it makes me think about wiring, right? So we're wiring money constantly, and typically you've got to get a note from somebody at the senior level management to say, I'm approving, this wire of X million dollars, right? And a lot of times you have, like Adam said, admins kind of executing on that because you have a shop of 10 people. Now, how do you create control around that, especially when you've got people hacking into systems, and sending these wire requests, right? So I don't know if you guys have read about all of these instances where, people are faking email addresses, sending out wire requests as the CEO of the firm to the person that they know is going to be frightened to escalate because the CEO is sending a wire request, so they execute on it, and it's going to, a bank or somebody in Russia or one of these nation-state actors who have been kind of plotting against, this type of activity. Creating, and that's one of the biggest things that I think about for the smaller firms is creating some sort of, check and balance and approval process, making sure that, wires aren't sent without proper either verbal or, some other form of approval.
Now, actually, on the wires, a very practical point. When I first started doing hedge funds 20 years ago, you would include in the subscription package the name of the bank account number, the routing number, and to whom the wire should be sent in the subscription package so that the investor has all the information he needs. He signs off the subscription package and then sends his wire to the information in there. Now, our model documents do not include that information for a very good reason, because it's possible to use that bank account number and routing information with the technique you were just describing to get someone to essentially raid the transactions account. And so instead of providing that information that could be available forever, it's sent by a secured link that dissolves in a few moments. When the investor is ready to wire, he gets that information, he puts it in, sends the wire, and then poof. And that's the only way we found in order to protect that, other than perhaps a phone call, but then you have transcription errors because the
person is now writing down a number.
And I think, when I was helping run a small firm, because you're small, right, you're generally always going to have a CFO or controller, somebody, you're going to have the head of that firm or whatever. And if those two guys, among probably a couple of others, aren't chatting about stuff, something is wrong. So communication clearly is the most important thing. But, you get a vendor, you're worried about wiring and stuff. You kind of, and especially the stuff emails, right? So if you just flip it on and say, hey, take care of this, and it's from the CEO to an accounts payable person, you're probably going to run into a problem. But if you, at that point, that's where you've got to say, well, if there's that much separation, there is something that exists in terms of a real internal control structure to check and make sure. So for us, we always make sure, depending on which unit of the firm, that the correct entity owns the vendor relationship and approval process for anything before anybody in AP is going to send out any money. And that kind of permeates a lot of what we do, of course, vendor relationships of any sort, right? The same thing applies to when we're dealing with, our banking relationships on the trading side, and if we're signing new ISDAs and things like that, is who's involved. Obviously, the legal team is coming to somebody else in the business unit and making sure that it's signed by the proper person. That it's up to that person to what extent they're engaging and questioning. But again, do you know what's going on? Are you talking to your trader? Who's this? Do you need this bank to trade with him?
So there's always at least two parties touching that wire, whether it's the business unit that has the relationship with that vendor and the AP department. At least two different parties are touching that wire. That's great.
That's the check and balance that we were talking about before. I mean, that's a solid control.
But as part of that, your people need to know that if it doesn't make sense, they have to ask a question. And as you were saying, that admin who would never question the CEO needs to know, no, your job is to
do just that,
yes. Right? And let's make sure that there's not an issue. So, part of this is, the culture of compliance that we talked about, risk management as a culture, making sure that everyone realizes that they have to own it. And it's like the ads you see in the subway all the time, right? You see something, you say something, right? Well, it's the same thing in an asset management firm. Obviously, you're not dealing with, improvised explosive devices, but it has the same devastating impact on your firm if something goes awry. So, yes, in the culture of every firm has to be, if you see something, you got to say something.
I think we've all met some very difficult fund managers in our day, and I can't think of one of them that would say, I can't believe you're coming and asking me whether you should be sending this $5 million wire, and that you were actually checking to make sure that it's a valid wire. With maybe 10 years ago you see that because there wasn't as much of this cyber risk out there, but I can't think of one now that would be angry that you were just double-checking to make sure that you were sending out $5 million to the right place.
Well, and I think you raise a good point, which is if it's a $50,000 wire or a $10,000 wire, maybe not.
Yeah.
And maybe in every organization you scale those second and third levels of approval based upon the impact and magnitude. Mm-hmm. And that is where, it's continuous proactive improvement, right? You have to continuously say, how can I make this better? Do we really have a risk at, $5,000? Maybe not. Maybe we can move that to 20. Yeah. You know what I mean? So every organization should have a dynamic process to say, okay, well, this is the risk we thought we had. This never materialized, so now maybe we can push that up a little bit and give a little bit more latitude without the constant ratiocination. So I think, everybody needs to think in terms of risk being a dynamic issue and how do you constantly assess the evolving risks to our businesses. So with that in mind, walk us through slide 7, first, second, and third lines of defense.
So what I would say about this is it's built a little bit more. This is the typical 3 lines of defense that you see in larger organizations. So I get a lot of questions. All right, my firm's 25 people. We're not going to be able to structure our risk framework in this fashion, but I'll walk through what they are and then how to kind of consolidate them for a smaller fund. So the first line of defense is really the business owners, right? So these are the folks that are interacting on a day-to-day basis, right? So those are the real owners of all risk, right? They're the ones that are interacting with vendors. They're the ones that are interacting with investors. They're the ones that are making investment decisions. They really own the risk. The second line of defense in a larger organization is really kind of setting boundaries for the business owners to say, okay, well, you have to operate within these guardrails, so to speak. So like we were talking about before with wires, it's setting some sort of limits that people can trade on. It's setting some sort of limits for, wiring for, I can bring in a new vendor, but I need to get approvals. It's creating, the second line is really creating policy, if you will, for what the business is doing without trying to hinder the business's agile nature, right? Because that's the last thing you want to do. You want to let traders and front office folks be good at what they do, but you still want control around it. And then the third line of defense is really kind of an audit type role, which is evaluating through testing, how well those controls operated. So really what you look at here is the first line of defense of the business. Second line is how well the control is designed, right? How well have you designed your control environment? And third is really looking at how well it's operating. So what's the operating effectiveness of those controls? We talked a little bit before in the principles section about continuous proactive improvement. I look at the third line of defense as trying to constantly improve on what the control environment is. Now, the typical question I get asked is, all right, well, we're not that big. How do we structure this? So really, I combine the second and third line of defense to just say, okay, well, now we've got the business ownership. We want somebody that's separate from business to be able to create that control environment and then evaluate it, right? So we can combine the second and third line of defense as kind of a governance oversight role / audit, even though people don't like to use that word very often, but it's true. You have to be self-governing, and that's the way you do it is through operating and design effectiveness reviews.
So, Jeff, again, as a small business owner, is this something that you can do, or is this a degree of complexity and cost that you would find in your firm is just not sustainable?
So other than the not sustainable part, yes and yes. So, look, it is a lot, but the answer is that we do it because we have to do it to protect the firm, to protect our investors. So for us, we do have certain functions laid out, in processes laid out that are expected to happen. And what we do is we're testing them throughout the year. It's not just the annual review that's required by the SEC, and all right, let's take a look back and, let's update maybe the risk assessment and put it away and we'll see how we did at the end of next year. No, that's what a compliance manager or whoever you've assigned, if it's a small business, is responsible for doing, and so there's the ongoing day-to-day stuff that's being tested. And then there is sort of the curveballs that come in any given day, and then what else should be tested that we're not maybe testing throughout the year. And again, that goes to the risk assessment. But you shouldn't just be putting it away and forgetting about it unless it's just so low a risk across the board. It's remote, the impact is tiny and so on and so forth, that at least you take a look at it on an annual basis. But so the answer is, yeah, we are looking at it throughout the year. There is a real cost to doing that. We've got to think about who to engage and who's the best people to include in any of these things. And from where I sit, I'm trying to assess whether, let's say, if it is our compliance person doing that, do they fully understand the full ramifications of the issue? And if the answer is no, it's one of two things. Either explain it and make sure they get it before moving forward, or two, others to be engaged to assist in the process and figure out what really is appropriate and how do we come to conclude that, we're in good shape or we need improvement.
So I have 4 kids, and one of them is incredibly bright, but he's unmotivated. And so to get him to get good grades, I started to pay him. $20 for an A, $10 for a B, $2 for a C. He gave me money if he failed. Yeah. So, and it actually worked very well. All of a sudden he started getting A's, which we knew he could get. I had to start to temper those numbers a little bit. So the question is, to what extent do you do it and do you tie it or recommend it that compliance and risk assessment be part of the reward system, where you incentivize people for getting green across the board, for example, or do you penalize people financially if they're consistently at the top of the riskiest part of the firm or whatever?
So the answer is yes, we do assess every individual in the firm on risk. So everybody, when we do our annual reviews, they also get a rating from the compliance group on risk, as well as HR, because of HR issues that could come up. And you can, so if, let's say it's a scale, right, so most people expect it to be at the middle, right? You expect it to do what you're supposed to do. But there are things that can obviously give you a little bit more, so there's a benefit there. But if you're dinged, then there may be monetary implications, and frankly, if it's pervasive, you certainly put your job at risk. So we actually do that. We have a process whereby they are informed of violations. We'll often write it up and put something in a file that, they've agreed and notified it, or at least there's some kind of memo to the file that we've done something. But it's important, and it's amazing that when you actually do that, they're like, oh, but I didn't know that. It's like, what do you mean you didn't know that?
You signed it.
Right. So you sign the document that says you've read our compliance manual or code of ethics or HR manual or whatever. You sat through training on this, and now you say you didn't know that. That doesn't usually go over well, right? But you say, well, now you definitely know, and now if there's another violation on top of that, what's the excuse this time? And you really don't want there to be that next time. So you've got to, make sure. But usually when you have a next time, it's sort of like, but this time it's different. And what you've got to do is kind of make sure that they think, like you talk about holistically looking at the firm, that they're looking holistically at what they do, and that not every instance is unique, right? And that, just act properly. And then now they really have fear, right? Because if you've gotten a second warning for something that is, whether it's compliance or HR, you start to say, they're serious about this, I need to change my behavior. And what we have found is where, although very rare, I will admit, where you have sort of a second warning to somebody on something, that all of a sudden their behavior dramatically changes. And actually the pendulum goes too far the other way, where now they're checking with everything. It's like, stop. Like, we're adults in the room here, let's move forward.
Yeah, the scrupulous conscience is as bad as the unformed conscience.
Uh-huh.
We need people who understand what they're supposed to do and not worry about every piece, because then they become ineffective.
And I just want to make sure, and before we run out of time, I want to make sure, and you already had it open to the page, but I'd like Sean to talk for a few minutes on slide 8, which is the approach. So everything we've talked about so far is nice and great in theory, and it's a lot of words around what would be nice and what you should and shouldn't do. Slide 8 is something that Sean put together that tells you how to do it. And again, it can be scalable between the different types of firms, but it's important to see, okay, yes, you need a culture that has the tone from the top that is very risk sensitive. Okay, so now that we've got our boss saying that risk is important, how do we go about actually implementing a risk assessment program?
Yeah, and thanks for the tee up on this, because this is the money slide, so to speak, in the deck. Because coming from the private side, from the fund I was at, it was a large private equity firm. I worked with a lot of the big four and some consultants, and we would go to a lot of these seminars and listen to them, but we would really never get much to take back with us to go to our boss with and say, here's an approach. So I wanted to change that. So what we did here, and I'm not going to go through every single step here because it's pretty well documented, but what we did here in slide 8 is really give you a launching platform to get your risk assessment process underway. What does it take to get this going? What do I need to do? Who do I need to involve? What are my deliverables, which is most important, I think, as part of this, because you start talking about, these pie-in-the-sky theoretical kind of, risk governance frameworks and principles and things like that. what I wanted to do is actually say, okay, what are the results of these processes that I'm going to do, and what are the deliverables that I can actually give to my boss and to, any sort of risk committees or things of that nature. So what you have on slide 8 is really what the 5-step process is for implementing a risk assessment across the firm. And then below that, you have your activities of what you need to do, and then the deliverables below that. I'd also just skip to slide 9 if we could, because I know we're running up against the end of our clock here, and show you how I think the most effective way to report on these risks are. And it's really a heat map, right? So it's likelihood of occurrence, but the magnitude of impact. So a lot of times we sit there and talk about a risk that it'll close the firm out. But people forget that you have to talk about the likelihood. So if your risk is that, Russia's going to hack or China's going to hack into our system, steal our investor information, and distribute it to everybody, and you're a, $200 million firm based in, Ohio or wherever, the likelihood is not so high that Russia's going to be focused on you. No offense, I'm sure you're great at what you do, but I'm sure Russia and China aren't as much focused on you. So that's going to drop your rating a little bit. And I find the heat map and some of the other attachments we have in here from, slide 9, 10, 11, 12, the rest of this deck really lays out the framework for you. And as always, KPMG is here to help, too, if you guys, have additional questions to the process and how to implement it and scale it right.
Well, I'd like to thank our speakers for joining us this afternoon. Jeff, thank you very much for coming in and sharing your insights from the consumer side, the guy who pays for all of us. Thank you very much. Adam and Sean from KPMG, absolutely. And for my colleagues at Pepper Hamilton, I'd like to thank you for your attention at the program, and we'll see you next month. The topic next month is going to be fund leverage, or fun with leverage. So we'll see you then. Thank you very much.